May please, Your Honor, I, Mr. Khan, represent the defendant, Mr. Jamie Cox, and this is an application on behalf of the defendant for a plea in mitigation for the defendant who has been charged for attempted robbery under Section 11 of the Criminal Attempts Act 1981 and for possession of offensive weapon under Section 11 of the Prevention of Crime Act 1953. The defendant has entered guilty pleas to both the counts on 29th May 2020 at the PTPH. My plea in mitigation today will focus on the offense itself by addressing the relevant provision of the sentencing guideline, and then I will deal with Mr. Jamie Cox's personal mitigating circumstances. The aim of the plea is to persuade the court not to consider the defendant as a dangerous offender or impose any life imprisonment or any extended determinate sentences under the Criminal Justice Act 2003. May I now refer you to paragraph 2 of my skeleton argument, where I have listed all the relevant documents that I'll be relying upon during my submission. Does Your Honor have all the relevant documents that I'll be relying upon during my submission? Have you had the opportunity to go through it, Your Honor? Much obliged. May I now refer you to paragraph 3 of my skeleton argument, where I have listed all the relevant laws that I'll be relying upon during my submission. Do you require any assistance regarding the relevant laws, Your Honor? Much obliged. May I now refer you to paragraph 4 of my skeleton argument, where I have mentioned the offense category. Before that, may I confirm that you have had the opportunity to go through the PSR, Your Honor? Much obliged. On paragraph 4 of my skeleton argument, for count 1, which is attempted robbery, from the relevant sentencing guidelines, it is submitted that in relation to culpability, it falls under Class A, which is a high culpability because there was a production of bladed article to threaten violence. For this, may I refer you to the first witness statement of Paul Osborne, paragraph 5. Here, he has stated that, as Jamie looked down to his right hand, which made my eyes follow and do the same, I saw that he was holding a large kitchen knife in his hand. It had a steel handle and the blade was 9 inches or bigger. In relation to harm, it is submitted that the offense falls under category 3 because no physical or minimal psychological harm was caused. For that, may I refer you to witness statement the first witness statement of Paul Osborne, paragraph 7. Here he states that I wasn't frightened, but clearly Jamie wanted me to be scared so that I would give him the money from the till. The offense range of this offense is 3 to 6 years custody, and the starting point is 4 years custody. Your Honor, for the count 2, which is offensive bladed article and offensive weapons, it is submitted that in relation to culpability, it falls under Class A because the bladed article was produced. For that, may I also refer you to paragraph 5 of the witness statement 1 of the Paul Osborne that I've just mentioned. In relation to harm of this offense, it falls under category 2 because minimal stress was caused to the victim. For that, may I refer you back to the witness statement 1 of Paul Osborne, paragraph 7, which I have also mentioned before. The category range of this offense is 3 months to 1 year's custody, and the starting point is 6 months custody. I will now be moving on to the relevant aggravating and mitigating factors, and for that, may I refer you to paragraph 5 of my skeleton argument, Your Honor. In relation to the statutory aggravating factors for attempted robbery, the date of the conviction by the defendant for a previous conviction of robbery was in April 2000. For that, may I take you to the summary of previous conviction page number 14. This is relevant since its nature is similar to that of the current offense. It is submitted that since the current offense have been committed after a gap of 20 years, the previous conviction may be disregarded on the ground of lapse of time. May I now refer you to paragraph 5b of my skeleton argument, where I have mentioned that in relation to the statutory aggravating factors for the possession of offensive weapon, the date of the conviction of the defendant for a previous offense of possession of bladed article was in January 2007, as can be seen from the summary of previous conviction, page number 15. It is relevant as its nature is similar to that of the current offense, but there is a gap of 13 years between the two convictions, which makes it subject to be disregarded by the court. On paragraph 5C of my skeleton argument, I have mentioned the other aggravating factors of this offense. It is submitted that the defendant is heavily dependent on drugs and the offense committed by him under the influence of drugs. He started taking drugs from a very young age, and this increased as his marriage of 15 years broke down and he got estranged from his daughters. As a result, his mental health deteriorated, and the fact that he is currently homeless and the regular drug taking motivated him to commit the offense. For this, may I take you to the PSR report, page number 11. It starts from paras 2 to 5. Your Honor, now I would be discussing few mitigating factors and I will be wanting the court's attention on it. For that, may I refer you to paragraph 6 of my skeleton argument, where I have listed the mitigating factors. It is submitted that the defendant had little or no planning for the commission of the offense. He was seen waiting outside the shop for 10 minutes before he entered it, and the entire incident lasted for just 20 to 30 minutes. He only asked for the money after paying for the lager and was about to leave the store. When Mr. Rob Green came in, he put his knife back to his trousers. For that, Your Honor, may I take you to witness statement 1 of Paul Osborne, page number 7, paragraphs 10 to 14. Here, Paul Osborne states that Jamie put the knife in the back of his trousers to hide it, and Rob came into the store. Rob realized straight away that something was wrong and asked Jamie what was going on. I told Rob that Jamie had pulled a knife on me and demanded money from the till. Rob asked Jamie if he had a knife, and Jamie said yes. Jamie burst into tears. On paragraph 7, I have submitted that the defendant showed remorse to his actions, as while leaving the shop, he repeatedly apologized to the victim. For that, may I refer you to paragraph 14, page 7 of the first witness statement of Paul Osborne. Here, he says that they both then left the store. As he was leaving, Jamie pushed open the door and called to me, "I'm sorry, Mr. Osborne, I'm sorry." According to the probation officer, the defendant seemed to be genuinely concerned about the effect his actions had on the victim. For that, may I refer you to the PSR, page number 11, paragraph 1. Here, according to probation officer, it is stated that Mr. Cox appeared genuinely concerned about how his offense will have impacted upon the victim, as he described him as a nice man who he has known for many years. On the paragraph 8 of my skeleton argument, it is submitted that the defendant has taken steps to identify his problems relating to offending and drugs. He has been taking prescribed anti-narcotic medicines regularly. For that, may I refer you to PSR paragraph 13. Here it is stated that whilst he has been on remand, he has engaged with the prison drug treatment services and is prescribed methadone. He reports that drugs and alcohol are easily available to him in prison, but that he chooses to not use them. May I now refer you to paragraph 9 of my skeleton argument, where I have talked about the reduction for guilty plea. It is submitted that Mr. Jamie Cox is entitled up to 1/3 of the reduction of the sentence that the court would impose on him today. Defendant had indicated guilty plea at the first opportunity, and since he has pleaded guilty on the first opportunity, it is submitted that 1/3 reduction of the sentence should be granted. I will now move on to assess the dangerousness in relation to the defendant's offense. For that, may I refer you to paragraph 10 of my skeleton argument. Your Honor, it is submitted that attempted robbery is a serious specified offense under section 224 of CJA 2003. However, it does not qualify as a listed offense under part 1 schedule 15B of the Criminal Justice Act. Therefore, section 224A and 226A will not be applied here. Also, imposing life imprisonment cannot be justified as the offense committed does not pose a significant risk under the meaning of section 225 of Criminal Justice Act 2003. Moreover, the pre-sentence report suggests that Mr. Cox is assessed as posing a high risk of serious harm to the public when in the community setting, and there is a risk of future reoffending. For that, may I refer you to paragraph 12 of the pre-sentence report. Whereas Section 229(1)(b) requires the court to assess whether there is a significant risk to the members of the public of serious harm occasioned by the commission by him of further offences. Therefore, in relation to the PSR, Section 229(1)(b) is not satisfied. Your Honor, in relation to the nature, background, and the circumstances of the current offence laid down in R versus Lang case, the court should take into account the defendant's socio-economic situation, accommodation, employment, any history of substance abuse, education, associations, relationship, and drug or alcohol abuse, defendant's offending history, defendant's thinking, attitude, supervision, and emotional state towards his offending. Hence, in relation to both Section 229(1)(b) and the factors laid down in the case of R versus Lang, it can be submitted that the offence committed by the defendant was not significant enough. Conclusively, may I now refer you to paragraph 11 of my skeleton argument, where I have discussed the totality principle. Defendant's offence of possessing an offensive weapon is secondary to the main offence of attempted robbery. Hence, it is suggested that the defendant receive a concurrent sentence for that instead of a consecutive one, because the secondary offence emerged from the same factual scenario. Unless I am of further assistance, these are my submission.